Is the petitioner?
On the last occasion, the learned advocate appeared online. Your lordship had directed him to personally be present in court, to physically appear.
কেউ লিঙ্ক নিয়েছে নাকি? কেউ নিয়েছে?
My lord, my lord, may I submit one thing in this matter, my lord? In item number 2, my lord, although the legal heirs are not party to the contempt in the application, but they came before your lordship to inform you that the alleged contemner, whose name is mentioned in the petition, he already expired, my lord. This is the death certificate. That is to inform your lordship that contempt.
Is he a party?
No, legal heirs are not party, but they came before your lordship to inform that the original contemner expired.
The contempt,
that person whose name, the contempt, allegation of contempt is there, he expired, my lord.
that is
Shudin Mondol.
Elena Pereira.
Lordship, that is item
Lord,
number
it's
2.
CC 45.
I am
Alan
appearing
Pereira.
item number 2. Lordship, at the outset, I tender my apologies in case your lordship returns a finding that there has been any act of contempt. Lordship, otherwise I am taking a point of maintainability. Before that, I will just address on merits once. Lordship will kindly appreciate this is with respect to your lordship payment.
No,
of
this is you are appearing in
item number 2, your lordship, for Eileen Pereira.
Come to item number 1. You are not there.
Item number 1, your lordship.
Oh, item number.
My lord,
So there are 2 contempt
2
applications.
contempt applications. Item number 2, I am appearing.
You are for Sudhin Mondol.
Yes, my lord.
No,
Lordship, I am for
Pereira.
Shudin Mondol.
You are for
Shudin Mondol actually
Alan
expired,
Pereira.
my lord. The legal heirs came before your lordship.
my lord, if you kindly allow, if I continue, my lord, first.
Pardon?
My lord, if you allow to continue me, I am petitioner in person. Okay.
No, just we are ascertaining. Mr. Chakraborty, you are for in APO in
CC 45 of 2026.
Your lordship, that is item number 3 before your lordship. Perhaps.
No.
I apologize. That is item number 2 before your
Yes.
lordship. I apologize.
Yes.
In item number 2, your lordship, I am appearing.
Then for the contemner.
For the
Who is the
alleged contempt.
contemner?
Eileen Pereira.
That is Prothumta.
That means you are the contempt on behalf of the
I am
contempt.
the alleged contempt, your lordship.
You are the alleged
I
contempt.
am the alleged
Have you got a copy of the contempt
I
application?
have a copy of the
My lord,
contempt application.
affidavit of service. Service
Without
and
the
receipt.
court's order, how could you serve?
Okay, I had no idea.
Now tell us what is the contempt.
My lord,
Give the service. Award.
my lord, if you allow to brief about
Which order you are saying they have violated?
13th January 1994. It's in page number
Very good. Page number 36.
page number 36. Yes, my lord.
So you read the order. Read the order.
Okay, my lord, this order is passed by Justice.
All right, we
Justice-
understand. Read the order.
Order is the special officer is given liberty to enter into an agreement with additional clause of rent enhancement of rent at the rate of 10% after every 3 years. And the tenant must undertake to pay a proportionate share of corporation rates and taxes in respect of the flat in question. And as a special case, such proportionate share shall be include owner shares and occupier shares as well. Sri Rabindra Chandra Ghosh, a tenant, is directed to be personally present in court on 3rd February 1994 at 10:30 a.m. when the matter will appear in the list as for order, and to explain why in respect of the undertaking given before this court he has not vacated the premises. JM Lander, another tenant at the premises, is also directed to personally present before this court on 3rd February 1994 at 10:30 a.m. The special officer is directed to the parties to inform and the aforesaid tenants accordingly. All the parties to act on a signed copy of these minutes of this order on the usual undertaking.
So come to page 38.
Yes, my lord.
This is the letter you have addressed to Elena.
Yes, my lord.
In this, you are saying, first paragraph, it has been stopped. Rent has been stopped from September 22.
Yes, my lord.
September. So we are in 2026.
Yes, my lord.
What have you done in the meantime?
I was trying to settle all amicably.
You are appearing. Is this relating to one particular flat?
Yes, my lord.
Rent in respect of one particular
No,
flat.
for this tenant, Alain Pereira. Yes, particular flat, correct.
Occupying a particular.
Yes.
He has stopped paying you rent since 2022 September.
Yes, my lord.
But what is the direction in this order at page 36 upon Elena Pereira? What is the direction upon
The
her?
direction is to comply the order. Direction was given to continue the rent to the landlord every month,
Hmm.
as well as
So
rent.
you are one of the heirs of
Basant Kumar Chokhani, who was absolute owner of 127A Park Street, as per decree dated 5th September.
you are appearing. You are Mr.
Ashish Chokhani.
Ashish. Now, who are your other heirs? This rent are distributed amongst the
Other heirs. The other heirs are Jayashree Chokhani, Madhushri Chokhani, Poonam Chokhani, and Rashi Chakravarti.
who used to accept the rent.
We all, in a mutual understanding, as per mutual, we all used to collect
The
the rent.
special officer was discharged.
Yes, in 1996, after handing over the
Yes,
120.
Mr. Chakravarti, why you are not paying the rent?
Your Lordship, may I just indicate in 2000 on instruction I'm indicating on and from 2022 there is a corporation demand notice pursuant to which, Your Lordship, we are paying the particular amount, Your Lordship, to the corporation because, Your Lordship, there are certain statutory dues. That is my, Your Lordship, on merit. These are my instructions. Otherwise, Your Lordship,
Chakravarti, up to September 22, you used to pay something.
I used to pay something on and from October 2022, Your Lordship, I am paying to the
Then you
corporation.
ought to have brought that to the notice of the court that I am not being able to do this because of the ABCD reasons.
Your Lordship, which is what I was indicating because I was served with this just some time back. I will come back with an affidavit of compliance if so. Otherwise, Your Lordship will kindly consider this is barred by under section 20 of the Contempt of Courts Act.
We want to
Because-
settle the
No, of course, Your Lordship. Which is why I tendered my apology and I did not take up
Please
this.
ascertain from your client.
Lordship will do that.
You have to explain to your client there is a court's order.
Most certainly.
So what she is
Yeah.
Huh?
My lord, they have already paid for the month of August after filing this.
they have
yeah,
paid.
They have paid rent, but not the arrear. And also, they are not paying the increased rent from 2022 to 10% and the KMC rates and taxes as per the direction of the Honorable High Court order since inception.
Now, how much you are getting as rent?
They have paid 4,000 rupees.
4,000.
Yeah, for this August month, from the month of August. But the arrear is still pending, and along with the KMC rates and taxes and 10% increase of rent from 2022. Sorry.
You file a short affidavit
We'll file that. Your Lordship.
explaining what steps you have taken and
Lordship
why
will
you
do
are
that.
not inclined to pay.
We'll explain our conduct, but Your Lordship will kindly keep the point of maintainability open. That is my short, sir.
That you have.
But of course, in contempt jurisdiction, of course, I ought to explain my conduct. Your Lordship, I bow down.
It is a continuing cause of action, Mr. Chakravarti.
Lordship, perhaps
You
Your
are,
Lordship,
you are arguing on limitation. Why you are arguing on limitation?
Lordship, I am perhaps, Your Lordship, subject to correction.
So
Because, Your Lordship, from the first act of contempt, Your Lordship, there is a period of 1 year that is calculated. Subject to correction.
period of 1 year from the date of violation.
From the date of violation.
Right. So if you say that it was September 22,
22.
it has ended in September 2023. Why you are coming in 26? That will be your argument. But this act of non-payment of rent is a
Lordship.
continuing cause of action. So your maintainability is subject to what you argue.
Lordship.
Whether it will survive or not, that is to be considered. But we will not incorporate that. You explain your conduct to us.
Of course.
Then if required, we will dismiss the petition. But this is a long pending case from 1994. You please ask with your client. August rent has been given.
Yes,
So far as the arrears and everything,
why?
we are just now going to. You can settle the issue, Mr. Chakraborty.
Your Lordship, in fact, my instructions as on today
Just
morning,
ask your solicitor to sit with the
we'll do
person
that, Your Lordship.
and
In fact,
to take. He has come with a grievance. How it can be redressed?
Most
Then we can go on to
most certainly. Your Lordship.
heard the petitioner appearing in person.
My lord, his legal heirs came before your lordship to intimate before this honorable court that the person already expired. So this particular contempt cannot become before infractuous before due to the expiry of that particular person. But the fact is that similar case happened that corporation issued a notice to us to for rent
How
attachment.
many years Sudin Mondol has?
Sudin Mondol expires on my lord in the year 2002, 22. 22. And at that at similar time, my lord, corporation also issued a notice that for rent attachment.
Then after 22, you did not pay any rent.
No, it was attached. It was directly paid to the corporation, my lord.
Without paying him his share.
His share.
That since the corporation taxes have increased.
Yes, my lord, corporation is as per the notice of the corporation, my lord. As per the direction of the corporation, we have done that.
That we will consider.
My lord, there is no information of the death of Mr. Sudin Mandal.
এই নোটিশটা আছে না মারা গেছে
Of the legal heirs to him.
Yes, my lord.
They have sent a letter just 2 weeks back. I received 1 week or 2 weeks back. I received the letter.
It's an appropriate application.
Okay.
You are in appearing in person, you don't know the who advises you. Any advocate is there with you.
No, my lord.
Nobody appeared as an advocate on your behalf.
No, my lord. Agreed, they will pay the amount of the along with the arrear and with the increase of 10% rent. That is okay, but I had no idea he has expired, Mr. Sudin Mandal, in 2022, which I came to know 2 weeks later.
There are certain formalities. You're behind that. Mr. Chakraborty is sitting. He will guide you. Person expired, legal heirs are there. Kindly guide him.
The petitioner appearing in person prays for leave.
Original side extremely urgent. Oh,
Yes.
mentioning Lord,
Happen
Lord,
inside the- Not
Lord,
now.
it is relating to a program that we wanted to, Lord, organize tomorrow on the day of Independence Day, that we applied earlier. Our application is of a previous application, but not the persons who applied subsequently, they moved a writ petition and they have been granted
What
permission.
can be done?
So, my lord, our application has been directed by the learned judge to be decided by
You have
today.
filed, where is your appeal you have filed?
My lord, kindly allow me to file it, my lord, and move it today, my lord, if my lord allows us, my lord. Otherwise,
Okay, how it is
this
possible?
will
Mr.
become
Chopra?
infructuous. If it could be, my lord, if
One
my lord,
group went to the court said no. Now another
no,
group
they
comes.
filed the writ petition.
Huh?
Lord, we applied, and thereafter, the writ petition in the trial court, they also applied after us. So, my lord, they moved the writ petition, and they have been granted permission by the learned single judge, despite being informed that our
So
application
your appeal is against which order?
against the order of the learned single judge, my lord, allowing.
You are not a party.
I was the respondent number 6. We informed the learned single judge. My lord, may have a look at this. Learned single judge that our application is prior in time.
So very good. You were impleaded as parties means you are pro forma respondent.
Respond.
Because you were also espousing the cause of the petitioner.
No, Lord,
It is a question of holding any organ.
Lord, we are a different organization. They are a different organization.
Then
We,
who will hold the
Lord, that's the issue. We applied prior in time, and their application, which is later in time, has been allowed by the learned single judge.
First year.
May I assist? I was there in the matter, my lord, for the
Yes,
state,
you
my lord.
people are here to assist us.
Two applications, my lord. One of 29th of July, one of 30th of July. We haven't granted permission to both of them. Both were under consideration.
Oh.
So, my lord, the application which was made by the one of the petitioner there in on 30th of July,
There are two organizations.
two different organizations, my lord.
What do they want to hold?
They health checkup camp and blood donation camp, philanthropic acts they want to
They
do.
want to hold it
No,
jointly or
Separately, my lord. So,
the same place.
yes, the respondent who is before my lords,
My
they have
application is
applied
prior
on
in time.
29th.
Yes.
They have applied for the permission on 29th, whereas the petitioner, the appellant, the respondent herein, they applied on 30th. So, learned single judge considered and allowed the application which was filed on 30th, my lord. Their case is that they have filed on 29th, so their case should be given on precedence. This is the case, my lord.
So who is refusing them permission?
My lord, nobody, there was no permission at all. Even we stated before
So
these.
he applied for permission to whom?
Lord, I applied before the
Deputy
police
Commissioner,
authorities,
Central Division,
the
my lord.
deputy commissioner for Lord permission.
Mr. Mishro, you see that their organization also.
My lord, in one place, how can learned single judge order is there to hold there, my lord? How can we allow now at this
Lord, on
juncture, my lord?
29th we applied for holding.
Just-
Lord, আর কপি নেই অর্ডার দুটোই দেখাতে তো পারবো না।
You did not approach the court.
No, they approached the court.
How you are
But,
wanting a benefit in their
Honorable single judge, subject to correction, ought to have said, my lord, that the application should be considered by the authorities, my lord.
That is always there, they will consider.
No, my lord, the thing is that my
Mr.
application is.
Chakraborty, you did not come to the court.
My
Now you are taking, as an order has been passed allowing your other group to hold, you are coming in appeal against us against that order.
Yes, my lord, my point is that the honorable single judge, my lord, with greatest of respect to his lordship, my lord, ought to have directed the police to consider the applications,
No,
my lord, as per serially, but somebody would come to court and get benefit.
Your application was not being considered. You did not approach the court.
My lord,
They approached the court
my lord,
and they got the order.
they made us a party. They knew that we have also applied and we have constructed the pandas there.
Sorry, that is not available. Mr. Mishro, you see
My lord,
if the area permits, ask your police to see if the area permits, then whether it can be done.
my lord, our difficulty on our part is, my lord, same place. Both of them want to organize the program at the same place. Now, my lord, it is within the jurisdiction of New Market Police Station. my lord.
It's in Jan Bajar.
Timing same, my lord, 10 to 4. That is
Without
on the
timing, appeal.
4. This is a health
Blood
checkup camp, blood donation camp,
health checkup
this
camp,
sort of act, my lord.
eye
2
checkup
hours.
camp.
Yes.
So, my lord, that may be considered, allow both
My
of
lord,
them to
if
conduct
my,
the 2
if
hours.
my lord allows me,
That can be considered.
yes,
No, how
that
it
could be
cannot
done.
so. It is not
If-
there.
my lord, since I had fallen from my lord, from
Lord,
the
if the
state, my lord,
time could be
both of
limited,
them
that they
were
consider
disabled.
it from 10 to 12 and we do it from
You
12
cannot
to 2.
pass that order in your appeal. If
Lord,
they consider, we have
Lord,
no
we
problem.
were a party in the writ petition. We
Maybe,
pointed out
but
that
we
our
did not
application
come,
is.
Mr. Anyway, let us not quarrel over this issue.
conclusion one matter, my lord. This matter, my lord.
Original side, original
No,
side.
my lord, appellate.
Come on Monday, give a notice and come back on Monday. Yes, call the list. Mhm.
I'm sitting in adjournment of your lordship just for today. I am not.
We cannot hear you, sir.
Adjournment, your lordship, just for today. Oh.
Adjournment. Why did we keep it for any fresh matter?
Fresh matters.
You have completed service? No.
Service has been completed.
Have papers with you? The Monday week or ওই দিন কি অনেক আছে নাকি?
Two.
কবে? Sorry, Mr. Mitra.
My lord, pleases me.
Any urgency involved?
No, I don't.
Kindly fix it on next week,
It's
Lordship.
regarding parking of cars, my lord, on this road.
Oh, I see.
And in fact, there is another
That, Mr. Advocate General, it is your domain. You have to settle the problem.
It's wait, this dispute, my lord. There is another petition pending, my lord. It's a public interest litigation, if I remember it correctly. Before, my lord, another bench. But be that as it may.
Oh, then we will send
Lord,
it
this
there.
is the order. We are carrying the order. My lord, Justice, the division bench presided over by my lord Justice Bosak, my lord.
দেখি ওই
My
order
lord,
টা দাও।
চলে যাক না ওখানে ওখানে তো হচ্ছে।
Before yesterday, I had to hold a meeting.
In the meantime, if that is worked out, your problem will also be solved. 8th September. না ওরে
Your Lordship, the service is not complete yet.
Service not complete.
Kindly grant us.
তাহলে ফাইলটা করে ডেটটা দিয়ে দেয়।
ওই then সার্ভিস ইজ নট কমপ্লিট। ওটা কবে রাখলাম? 10 সেপ্টেম্বর। দি লার্নেড অ্যাডভোকেট
I am for the appellant, my lord.
এমন খবর পাঠিয়েছি প্রতিদিন সকালবেলা দেখা করতে মেরে দেবে।
Your direction was given for service.
Yeah.
My junior is not here, my lord.
ও বাবা, রেখে দাও।
Lord, it is served,
10 সেপ্টেম্বর।
my lord.
Mr. Tiwari, learned advocate applicant. আচ্ছা, এখানে একটা লোক।
একদমই কোর্টে ফাঁকা।
Service completed?
Yes. সার্ভিসটা এবার
Where
দেখি।
is your affidavit of service? Oh,
এই দাঁড়া দাঁড়া ডেলিভারি হয়েছে। ये सीनियर गवर्नमेंट एडवोकेट को देंगे सर्विस करने। स्टैंडर्ड
August 2022 memo of the DI. 18th of August 2022, which you challenged in the original application. That is which page?
योगा टीचर थे।
It's
Page 55, 54, 55.
বাবা yoga teacher এখন the process
To sanction post of physical. Come to paragraph 3, 4, and 5. Read paragraph 3, 4, and 5.
Of the order, my lord.
Yes, of the order.
My lord, question is that, my lord, yeah.
First you read, then you argue. We have heard the learned counsel. Got it?
Yes, ma'am.
Read it loudly.
For the applicants, during hearing, learned counsel for the applicant was asked to clarify as to whether the applicant has applied for teacher in Jawahar Navodaya Vidyalaya JNP in response to any employment.
So you have not applied for yoga teacher in response to any employment notification, but only with reference to a newspaper article.
Yes, ma'am.
That prayer was forwarded by the DI to the your NV to the Navodaya Vidyalaya.
Navodaya Vidyalaya.
DI forwarded it. In response, they wrote that there is no yoga teacher in our school. Only 2 posts of physical education teacher is there, in which a yoga teacher, those 2 posts have also been filled up.
My lord, my humble submission is that that is only for a particular school. But Navodaya Vidyalaya, as per the newspaper publication, it will be compulsory for all the central government schools.
To let the central government include yoga teacher.
Yes, my lord.
Let the central government include yoga teacher. There is no yoga teacher in any NVF school.
Kindly let there be a direction upon the secretary, under secretary to consider my prayer if there is a vacancy arises.
There is no vacancy বলে দিচ্ছে তো।
দুটো vacancy আছে, দুটো vacancy filled.
Read the letter, page.
Yes, my lord. Yes,
59 says what? Later, I am not being able to understand. Just on subject, what is the subject? Prayer from Mr. Pradeep Das for appointment as yoga teacher. This is the subject.
Yes,
now, what he is writing on the subject, this office has received a request letter from your office regarding appointment of the person in the capacity of yoga teacher. In this regard, this is to this has already 2 posts in physical education, and it is already filled up.
Yes, my lord. I bow down before your lordship. So that is only for a particular institution.
JNP is governed by MBS RO.
To the authority.
Yes, my lord. That is at page 51, my lord.
Page 51 under Secretary Government of India. Page 51.
You yourself in paragraph 2, you say Assistant Secretary informed that there was no permanent post of yoga teacher. আর কি বলবে বলুন?
My lord, the practice that my lord, practice is a trained yoga teacher. He is working for more than 12 years as a part-time yoga teacher. But here the already central government has declared there is more than 1 lakh requirement of yoga teachers who will be in future, my lord. That is why my humble prayer with folded hands.
When that matter is made, you apply. Who is stopping you?
My lord, only that I beseech before your lordship that there may be a direction upon the Under Secretary Government of India that to consider my case if there is a vacancy arises. My lord, let
It is
that
always open to you.
My lord, let that be given, my lord. Kind.
We are not stopping you, sir, but we cannot record in your order. You withdraw the petition, apply, we don't pass anything. Then when the fresh application is made, you apply.
Then at least allow me that leave to
Leave to withdraw, we can give to you. But
make a submission before the appropriate authority. My lord, kind.
But ভদ্রলোকের নাম মাহাতো। Experienced person, you know that what is to be done in the matter. If you want to go on with this, we have to pass an order. Choice is yours.
My lord, what the fact
In
is that
view of page 41 and page 59, 51 and 59, you have no case, Mr. Das. আর ভালো কিছু নিয়ে আসুন, আসো। The present এবার ধরো,
হ্যাঁ,
শরীর খারাপ করে।
জয়িতা করতেছ কোথায়?
My lord, my lord.
No, no. Vote for them.
Where is the order dated 30th June 2025?
নিজেই খুলে
বলতে পারবেন না।
2025 এর অর্ডারটা করবো
38?
দুটো order দেখতে হবে।
30 জুনটা কি
আচ্ছা, ওই জিনিস 30th June একটা entry
এটা এখানে
কোড করে দিয়েছি।
In full matter, my lord.
Mr. Chakraborty, first answer our question, then you will argue.
My lord.
Please answer our
My lord,
question.
out of 9 applicants, my lord, they were not capable because they are petty electrician, my lord, capable to move any further petition. Yet they have moved the petition before this honorable court just after my filing this application, my lord. And the what order passed in my case, similar order was passed in their case also. And my lord, thereafter, as per the liberty granted by the Honorable High Court, my lord, I moved this this original application 377 before the tribunal, my lord. But I do not know, my lord, what is their fate, my lord. They are at all able to move the matter before the CAT because all they are under without food and medical treatment, my lord. Because after 20 years of service,
Are we asking you that?
My lord.
We are asking you, has anybody from the earlier original application been regularized by the authorities?
No, my lord. No, my lord. No.
No.
No. All are removed, my lord.
Then how you are aggrieved by this order? This order, court has said that there is no conclusive evidence that there had been continuity in service. But I find some merit in the matter. That is why I am sending it to them. You produce all your relevant documents and they will take a final decision for regularization of your service. This is an innocuous order. It is in your favor.
My lord, only my fault, my lord. That
this order is in your favor, Mr. Chakraborty.
Yes, my lord, yes.
Then why you are before us?
Because
sir, you please tell Mr. Chakraborty that this order has been passed in your favor.
My lord, because my lord, this application, there was a direction, my lord.
Sir, you read paragraph 27 of the order. Read loudly, paragraph
my lord,
27.
what is the fate of the 27, my lord?
It will come later, page paragraph 27 first.
I shall make the respectable submission on para 27, my lord. Are directed to undertake an exercise for verifying the claim of the applicants regarding their engagement of DRM casual labor from the actor.
Please read. Don't stop. Read.
And to sanction order and engagement payment all this, they are also directed to give the personal hearing all this and this, my lord. My lord, simple thing, my lord. My respect to Sabun.
Will you read? Will you read and complete?
And the applicants are also directed to submit such documents, if available with them, to the respondent authorities after such verification, if it is established that applicants have actually been engaged as DRM casual labor as claimed by them in the respondent, are directed to regularize them. My lord, actually this order of regularization was passed in the previous order, my lord. Question, my lord, judicial question, my lord. There is a question of judicial discipline, my lord. This order, if I comply, my lord, so original order my favor, my lord, whereas the direction was to regularize and all admissible extent to grant all admissible benefit, just to inoperative that particular order, this order has been passed. And when, my lord, when respondents are strongly opposing the regularization on the ground of the plea of non-availability of the records, my lord. And my lord, so judicial authority transferring the matter to the executive authority for judicial decision. The question raised, my lord, creditability of the judicial institution, my lord. Already they have engaged the private contractor, my lord, removing all the 9 applicants who rendered more than 20 years service, my lord, directly under the department. Para 23 and 26, my lord, it will be more clear.
Mr. Mukherjee. Yes. Mr. Mukherjee, kindly come to the earlier order of the tribunal on 5th October 2021.
Yes.
That is at page 7, internal page 7 of the order impugned.
It is also recorded in the order, my lord. Last order.
22. Yes. 22 to ever kindly come to this paragraph. Yes. Page order has been quoted. Yes. You found it? Yes. Now kindly come, turn over the page. Yes. Court was of the made this observation. We are of the opinion that respondents are guilty of unfair practice, depriving these poor people of their legitimate dues most arbitrarily and in unfair manner. They cannot be allowed to continue with the deprivation as above only because they have no bargaining power. This is a finding of the court. You have not challenged this order.
No, my lord. Not
Abar
challenged.
কথা বলে, will you take your seat?
My lord. I beg apology. my
Please
lord.
take your seat.
My lord.
Kindly,
I beg apology, my lord.
Lordship, kindly, inner page 6, Lordship.
Yes.
Findings, page 17. Page 17. 18, kindly see. And thereafter, Lordship, it is to be clear, no documents have been placed to conclusively establish the claim of the applicants that they had been engaged by the respondent as a casual work and TRM in the absence of such documents.
We understand.
Yes,
But in
Lordship,
respect,
thereafter, Lordships, and the assistant 20, Lordship, kindly see 20. In our page 7.
Lordship.
additional Solicitor General has come today, Mr. Mishra.
Yes, yes.
Inform him,
Please,
inform him.
Do you ওর কথা শুনবেন? We want him for 5 minutes. He will appear and assist us. Pass over. Yes.
Please, just only one sentence, my lord.
একদম
I
যাবেন।
can clear.
বসুন, বসুন।
এটা কি?
Item 7, I am for the my lord petitioner.
আরে বাপরে বাপরে। কপি আছে।
Where is the order impute?
My lord, this is a public interest litigation.
Oh, public interest.
Yes, your lordship.
Mr. Mishra, you are there.
My lord, I'm being told that I'm there.
Transaction.
Any private respondent?
No, my lord, the petitioner's allegation is, my lord, regarding, my lord, corruption and the, my lord, illegal transaction between the inmates to provide the benefits of, my lord, like food and, my lord,
As no one appears on behalf of
My lord, Mr. Pritam Mojumdar is appearing for the petitioner and he is unable to attend the court today. I am praying for not today.
My lord, I am for the private respondent number 14, my lord.
Mr. Misro,
Private respondent.
যে বিএনএসএস সেটাকে তোমার
দেখি ছবিটা প্রস্পেক্টালটা দেখুন
এই তো স্টেট পার্টি
ইয়েস ইয়েস মাই লর্ড রেসপন্ডেন্ট নাম্বার 4 ইজ স্টেট
স্টেট
কি মামলা কি
জাস্ট ভুলে গেছি
স্পিন অফ স্টেটটা দেখে নাও
দেখছি সেকশন অফেন্স সেকশন
তুমি তো পড়ে পড়েছো বলো তো
An adjournment has been prayed.
Restoration application, my lord. I have served my
and I have for the response.
Affidavit of service, as file be kept on record.
And it's a batch matter. Proceed.
When it is fixed,
27th.
27th it is fixed.
27th of
This month, August.
Adjourn করতে হবে।
matters are also with us. And all matters have been tagged together. Whereas my lord's matter was there. Yes. Difficult to hear out. I took the point, the fourth division bench passed different orders. Which order we will follow? We will be seeking directions appropriately. And following my lord Justice Chakraborty's order, my lord, we have given appointments, so many appointments, sitting in code number 11. So many appointments. But the moment the modus operandi has been changed upon obtaining different views on different coordinate benches. So again stopped in giving appointment.
Evaluator service.
My lord, item number 10 and 11, my lord, Mr. D.N. Rai is appearing for
It was a matter for record. First original application which was filed, there was an observation of court that there had been unfair labor practice. These persons have worked, and it was matter with such observation, it was relegated to the authority. Authorities rejected that application. Then they preferred a contempt that since the court has made this observation, why you have rejected our case. Contempt application, an order was passed against that, and WPCT was filed. Contempt was dismissed. It is a case, and ultimately when the dismiss with liberty to challenge the order. Now the tribunal considered that order and has passed an order saying that I'm sending it back to the authorities to consider without any observation as regards the earlier finding of the court.
Of this honorable court.
So why we suggest, we are wanting to tell you as to whether if anything can be done, because the observation was
My lord, word is my commanders. I will surely, my lord, try my good.
Mr. Mukherjee is there.
Yes,
but I said that let me
my lord,
he appears.
my lord, let us have a word.
Yes, you have a word and then we decide the matter fine. Asho, the present yes. Next.
My lord, item number 10 and 11, Mr. D.N. Rai is appearing, my lord. I am praying for only not today, my lord. Can you take it up on Monday?
I'm suffering an interim order here. I'm suffering an interim order, my lord, here.
What is the matter, Mr. Rai?
My lord, this is about decategorization, my lord, of the employee. My lord, medical decategorization of the employee. The railway servant while was working in the post of the respondent before your lordship is the railway servant, my lord, who was working under the RPF. So, my lord, while working, my lord, he just accrued some disability, for which, my lord, he was decategorized from his previous post as constable in the RPF. Thereafter, my lord, he was placed and in the post of junior clerk in the railways. So while being posted in the junior clerk, while he was, my lord, getting the grade pay of 2000 in the RPF, my lord, his grade pay was brought down to 1900 instead of 2000. So, my lord, which I said is completely contrary to their own, my lord, railway establishment manual and everything, which specifically says in line with the section 47 of 1995 Act, that if someone, my lord, accrues disability, then neither he would be, my lord, placed, my lord, in a lower rank, nor
Want to know the facts, then what happened?
yeah, I'm sorry. So that my lord was denied. Against that, my lord, I approached before the learned tribunal. The learned tribunal, holding all this, my lord, railway circulars and everything, said that it was wrong on the part of the railways in degrading the railway servant from 2000 grade pay to 1900 grade, and accordingly, my lord, directed to reconsider the case of this respondent, my lord, in the light of the observation of the learned tribunal's order.
So they have not passed any order.
No, my lord, because thereafter they have preferred this before this honorable court, and in this meantime, my lord, they have obtained an order.
You are still in service.
Yes, yes, my lord. I'm 50 years of age, 58 years of age now.
Yes, sir.
Exactly on same.
Or otherwise any day next week.
Next Friday.
Grateful.
Ask him to appear. Tournament has been
previous order Lordship has passed. This issue is already covered by Lordship's order. I have placed that order.
For instruction is required, I have received the instruction, but is required to file the supplementary affidavit. Otherwise, it will be, this judgment has been produced after the filing the writ petition. After the filing the writ petition, the judgment, and so is required to file the supplementary affidavit, because this judgment, Lordship judgment, is not for filing before the writ petition, and you are not annexing the writ petition, and so I required to file the supplementary bill against.
We will take into consideration that we have already referred in our order. There is no requirement of supplementary.
Otherwise,
please tell us whether this judgment will guide this matter.
No, this judgment is not a covered, it is not a similar matter. That are distinguished.
Not a
similar.
Still, let's come to the order.
Kindly file the opposition of stepping up, and Lordship, in this matter, P.L. Narayan is a private respondent and Amarjit Singh is respondent, and who is entitled is stepping up. This is the case. P.L. Narayan is entitled or Amarjit Singh is
Yeah, just one. Let us go through.
That's Lordship. Okay.
এই সবসময় সিনিয়র ছিল, চিরঞ্জীবী সেটা ছিল, দুটো সবসময় সিনিয়র ছিল, ছিল না।
By assigning seniority or full protection.
Lordship, as I have already provided. WPCT 207.
Mr. Chakraborty, that is the wrong. What is the wrong?
Who have been rejected, paragraph
The
8 of the
proposition,
judgment.
yes.
Who have been
I am
rejected
coming,
that
I am
in
coming
view
to
of
that.
the Supreme Court order
That is coming.
to take a
Take that.
decision.
Yes. Lordship have challenged the order, the findings of the tribunal. What is the findings? That is stepping up. Proposition of stepping up has not been followed. Kindly come to the is stepping up. Lordship. Stepping out of the court.
29.
Proposition of stepping up. What it says to first paragraph A.
Where you have
both
annexed?
the same category. It
Page
is not the same
26.
The page.
Page 26.
Page 26.
20?
6. 26.
On the D. 2D.
Stepping up.
First proposition is failed to understand. First tribunal failed to understand first proposition of stepping up. That's what that is identical and the same category.
A.
Part
A.
A.
Page 26A.
Yes, A. But Amarjit Singh and private respondent B.L. Narayan is not the same category. He is a operative, Amarjit Singh operative and B.L. Narayan private respondent in telegraph. Yeah.
They were in different
Narayan, B.L. Narayan telegraph and Amarjit Singh operative. And the stepping up, the proposition stepping up the same category should be same category, but it is not a same category. That is submitting before your lordship.
Categories? What are the categories?
Categories, that is telegraph and operating. That comes instruction.
Mr. Rai was in which category?
Rai is operating.
Was of operation cutter.
Operating.
Operator.
Operator.
Operating.
Operator.
Operating department. That is department. Division.
Operating department.
Yes.
And Narayan?
B.L. Narayan is Telegraph Department.
Telecom.
Telegraph. He's all along, B.L. Narayan is all along senior. And Spain,
All along?
senior. B.L. Narayan, all along senior. He has appointed in 1976. Or Amarjit Singh is appointed in 1981. And pay scale is senior.
He was appointed in 1996.
76.
B.L.
B.L. Narayan.
And he was appointed in
1981.
1982. 82. 82.
And next, C, kindly stepping up C, proposition of C.
So, tribunal observed
that has not been followed, the stepping up, policy of the stepping up. This is the stepping up, the policy of the railway. That policy has not been followed by the tribunal. That challenge is that principle of proposition of the stepping up. That finding is wrong findings of the tribunal. That I have challenged.
Where is that line? He was all along junior. Where is that line in the order?
My lord, in the speaking order, my lord, they have stated so, and it's an admitted position. I am a junior. I joined late in 1982. We both were in the signaler group. Thereafter, I joined the inspector category in the year 1995. Thereafter, I was promoted to chief DTI in the year 2000. 23rd February 2000, I was promoted to chief DTI. The private respondent, my lord,
You were promoted when?
in the year 23rd of February to senior DTI in the year 1997.
And
thereafter, I joined the promotional post of chief DTI on 23rd of February 2000.
Where is that?
That is there in the speaking order, which they have issued.
Tribunal's order.
Tribunal's order, my lord.
Under page 4.
Yes.
You were promoted to the post of senior DTI.
Chief DTI, my lord. Internal page 4, paragraph B. As per avenue of promotion.
First line.
That is senior DTI. Senior DTI is prior to chief DTI.
Now, next, as per avenue, applicant was promoted to chief DTI. Very good.
In the pay scale of such and such from 23rd of February 2000. As per his seniority, and his pay was fixed at 7,450, whereas B.L. Narayana was promoted to the post of chief DTI on 1st of December 2002. That is after 2 years. Now, the underlining ratio was this, my lord, the past service or the tenure of length of service in the feeder post is irrelevant once the incumbent joins the promotional post. A senior should not draw lesser than the junior. Now, in the year 2002, my lord, when private respondent joined, he was already enjoying more pay scale than me. And that is the reason, my lord, these orders which were passed by the coordinate benches and affirmed by the Honorable Apex Court, that was referred before the tribunal. Maybe the avenues of promotions are different. My lord, this order, absolutely, my lord, kindly come to page 73.
Let us understand. In the promotional post of chief DTI, you were senior to?
Yes, by 2 years.
So when a person gets promotion, question of counting his service is irrelevant.
That was Lordship has held. Lordship has referred another coordinate bench judgment which went up before the Honorable Court affirming a Lordship's view. That is the reason Lordship kindly come to page 73 for once. If your Lordship allows me to read, I can read.
This is Namapada Rai.
Yes, that was referred by your Lordship. Similar matter. Exactly on the fact, similar point. Here also, the person joined, junior joined the promotional post earlier. And senior joined later on. And same principle was followed as your Lordship has already held.
Then why it was delegated for consideration on the basis of the
I first approached before them with a speaking order. They were not considering that.
No. Why they placed reliance upon the Supreme Court order?
Supreme Court order held the same thing, paragraph 6.
This was also shown to us when we passed.
No, probably not. This was referred by us before the tribunal, my lord. Tribunal also held that, yes, we are entitled to. There also, my lord, the juniors were getting more because of the upgradation in ACP. That is the reason stepping up was allowed. If you will kindly see Honorable Apex Court's judgment, it's very clear at page 74, paragraph 6.
Page 70.
Pagination, it's there.
Page
Pagination.
73 is the judgment passed by this court.
Yes, Your Lordship.
Supreme Court judgment.
That has been quoted in the order.
Okay. But their pagination is not telling, my lord.
Internal page 6 of the order.
Yes.
Read paragraph 6 at the bottom.
Page 170.
Therefore, it was a case where a junior was drawing more pay on account of upgradation under the ACP scheme. And there was an anomaly, and therefore the pay of the senior was required to be stepped up. Hence, in the facts and circumstances of the case, the High Court has rightly directed the appellants herein to step up the pay of the original petitioners, keeping in view of pay scale which has been granted to the juniors from the date they have started drawing lesser than the juniors. We are in complete agreement with the view taken by the High Court. No interference of this court is called for. Similar things happened here. I joined the promotion and post earlier. I was getting lesser. Now, he was all along senior, but that is not a, this is an admitted position, but he was drawing more than what I was drawing. That is the reason, my lord, stepping up was allowed in the coordinate bench judge.
What is the railway established? Kindly come to page 16 of the petition. Mr. Mukherjee is taking this point.
Well, these were all considered.
Taking rules and framed under serial number 5 railway.
My lord, probably these were all considered by the division bench, my lord, and also the apex.
Yes, Mr. Mukherjee, what is your submission?
Judgment of your lordship, that will refer the planetary lordship, and in the page inner page 4. Page 4. Inner page 4. The proposition of law laid down for the case of HON'BLE is squarely applicable to the
paragraph.
Paragraph.
Our order.
Page 4. Page 4. Page 4. Page 4.
Okay.
Inner page 4. Inner page 4.
Yes.
Position applicable to the facts of the present case. The SLP paper against the same also dismissed. But one thing, Kali lost.
Wait, we are not getting that line.
You
are reading
the city.
Paragraph 4, up. Top.
Yes.
Proposition in
Lordship judge, yes.
It's applicable to the facts of this case.
Yes. Facts of the case is dismissed. This one point kindly lordship very relevant lordship. The point of law keep to fail is for consideration of
Point of law.
Point of law, what is point of law? The ACP scheme. ACP scheme has not been challenged before the tribunal. Learned for ACP scheme has not been challenged before the tribunal. The tribunal has failed to understand to consider this proposition. What is the ACP scheme is there? ACP scheme is there, which the promotional post will be considered. Promotional post, not promoted post. Promotional post.
Promotional
Post. Promotional post.
So what is the wrong? Then it will apply.
Right.
What is the wrong there? You are saying Supreme Court judgment made it clear.
An ACP scheme.
They were not correct.
Judgment paragraph.
Seniority will be come to the appointment from the appointment. Will be counted from the appointment, not promotional post. Not promotional post.
No.
That is the point of law of a ACP scheme. And that has not been
So
followed.
you go to Supreme Court and obtain a clarification.
That has been not followed, Lordship.
Point of law kept
And
you are
Supreme Court
Mr.
is open.
Mukherjee, all right.
Yes,
That
yes,
point of law has been kept open.
they are kept open. The
So that point of law which has been kept open, you have to open it by approaching the Supreme Court.
That is
It
that
cannot be here.
that shall be filed and before the learned.
Who will file?
I am not.
Who will file?
Railway has not filed.
Railway filed the SLP and got it, and Supreme Court dismissed it. Well,
The rider, that point of law is
kept open.
but thereafter, my lordship has referred that order in another similar manner. It is placed before your lordship.
So I'm filing. I'm paying the matter to file to supplement everything.
Supplementary.
It will be clear.
Annexing what? There must be certain documents.
Certain documents and filed.
My lord is aware no new documents can be attached.
Yes. You refer the judgment. This judgment has not been annexed in the petition. And after the
That you are reconsidering. The tribunal has not said that you give the benefit. Tribunal has said, I am sending him back to you. See the order, Mr. Mukherjee, what the tribunal has directed. Tribunal, in view of the observation of the Honorable Supreme Court, you consider the matters. This is the only direction. The present disposition has
आप नहीं बोले
Your Lordship directed me to serve the copy upon the learned advocate Mr. Dotto. But he initially refused to accept that, and subsequently on my request, my lord, because your Lordship can see the learned advocate. Now, my lord, he agreed to appear on behalf of the executioner, respondent authority. Who? Yes, Dotto, who practiced. Yeah, Dotto. Yes, Dotto. Who did Dotto? Your Lordship that. You have something but initially he told me that I have no instruction, I got no vocal.
You tell us, do you want to serve him and come back?
But I have affidavit of service may
18th September. Yes. You're appearing.
my lord, in 14 I was there, but my lord, only for time, my lord, why should I appear?
It's not
Never, my lord, he made submission.
You said you're trying to see if any person is appearing to give him notice. Yes. Next item
15, Your Lordship, I am appearing for the Union of
राजू है तो ठीक है नेक्स्ट दिन हो
Lordship, on the last occasion, this was dismissed for non-prosecution.
Dada.
Your Lordship.
Yes, Mr. Das.
There is a can for restoration.
On the last occasion, Your Lordship, it was dismissed for non-prosecution.
We did not discuss earlier.
Earlier, yes, earlier.
What actually? Talk with your friend. Does she agree or not? And whether she is opposing or not.
No.
Restoration application has been filed on 21st May 2026.
It has been filed.
It's on 10th February 26.
On
এক মাসের মতো তো হলো না। It's a application. Section 5 application একটা You are appearing for all the respondents, madam.
Lordship, for Union of India and the Eastern Railways.
Have you served respondent number 7?
Yes, ma'am.
কোথায়? Have you served this application upon respondent number 7?
Yes, ma'am. I have served upon all the respondents.
Lordship, 6 and 7 are private respondents.
7. Where is the service upon them?
My lord, for this restoration, my lord, they are not.
Not required. Not required.
2nd September.
Obliged, Lordship.
Serve and file an application section 5 also you can file and send copy. That will be fine. Affirm section 5. Restoration application and serve upon them intimating that we will take it up on 2nd.
Fine. Grateful.
2nd অনেক হয়ে গেছে। 9th করে দাও, 9th September.
Sixteen.
That matter.
16, my lord.
I am led by Mr. P.C. Das. He is engaging in another court. Led by Mr. P.C. Das, he is engaging in another court. Lordship, I am praying for not to.
On the last occasion, my lord, same prayer was, my lord. Kindly fix the matter, my lord.
You are the
Respondent, my lord.
Are you suffering from the interim order?
No, my lord, it can be disposed of, my lord.
Then
I am suffering.
Disposed of.
It can be disposed of. Very short matter, my lord.
Better about.
Petitioner claiming the priority with the private respondent in respect of promotion, my lord.
Parity
Priority in the post.
that has been rejected by the tribunal.
That had been rejected by the tribunal. Thereafter, they filed third OA, and the honorable court directed to pass the regent order, and the authority passed the regent order, but they did not challenge the regent order, my lord.
Then what did they do? Without challenging, they filed afresh.
Press, my lord. They can't file the press.
Before the tribunal.
Yes, my lord.
That is pending.
No, my lord. And that has been dismissed, my lord. Before the court, my lord.
Yeah.
Time can 2 p.m. at least.
Time.
Lordship.
We are all day we are here. What you are asking?
Very well, my lord.
Don't like to visit this court.
Pakistan will. Yeah, man. Yeah.
Milord, I have been notes of argument. Can I ask for a final? No, Milord, not. Repeat it. I am for the Milord absent lordship. I am a new entrant to the brief, Milord. Therefore, Milord, but I from the orders, Milord, I could not.
Can I see?
Which one? No.
It was placed, I believe, before the tribunal.
Yes.
Taking notes of argument or for the respondent.
For the respondent.
No, you were the respondent.
Milord.
You are ready?
Yes, no, lordship.
You are also ready.
Milord, just a small summary of the matter, Milord.
But Mr. Trivedi, having checked up
Lorships.
this point that 50% will count towards regularization. This has been decided in another case.
Milord, as far as the Honorable Supreme Court is concerned, Milord, 2023, Milord, which I am relying upon, Milord. Milord, there is a departure, Milord. There's a very thin line as far as this case is concerned. What is falling, presumably from my lodge, is that in casual, supposedly a person who were casual employees, subsequently by an order of any honorable tribunal or the honorable court, or for any reason, maybe a policy of the government or a scheme, they have been regularized. Then what happens, Lordship? If they are regularized, they will get their normal pay for that regularized period. But for the period when they were working as casual workers, they were entitled to 50%. That was the, but my lord, here the case at hand before your Lordship, where I'm trying to draw a line is that in railways, Lordship, under the scheme, we have two type of employments. Lordship, one is temporary employment, another is casual employment. Now, Lordship, we, in this particular case, they were given temporary employment. My lords will remember in 1984, all tickets, there were this automated checking was not there. 84, 83, 84. So when there was a rush hour, my lord, everybody used to go and nobody had the time to check, and there was a loss to the public exchequer of the railways. So they appointed certain temporary employees under our rules, saying that they will be adhering and working and assisting the ticket collectors. And they were appointed temporarily in 1984. And the same scheme was followed, that there will not be a continuation, 3 days, 4 days in between, you will not be continued. And then again, maybe. Now that lordship ended up in 1984, they were given. And in July 85, lordship will kindly bear me. July 85, lordship.
Kindly come to page, internal page.
Of the impugned order?
Impugned
order? Impugned. My lord,
please check up this because
my lord,
paragraph 11, last line.
My lord, will kindly.
Respondents have rejected. Have you got?
Lordship.
The respondents have rejected the claim of the applicant for counting of 50% of his past service as ticket checking volunteer or his pensionary benefits.
Lordship.
Now kindly come to the issue is whether if you give the benefit of 50, he has worked for 10 years there, he will get 5 years notional benefit. Not notional for the purpose of disbursement of pension. Now kindly come to the operative part.
Gotcha.
That is at page, so last paragraph 60. Now in terms of the above judgment, applicant is entitled
Casual
to
work.
count 50% of the service rendered by his volunteer ticketer, which is treated as akin to that of casual worker with qualifying temperature as qualifying service for calculation of his pay. Not monetary benefit. Only he will get it. Maybe when you regularize him, and by the time he will retire, he will not complete 10 years of service. He will not get the pension anymore.
My lord, the factual matrix are slightly different. This person has taken.
Your argument is that he was temporarily engaged.
Lordship.
He was engaged temporarily.
Lordship.
Does not give him the status
Of a casual employee. I'm grateful. That is the best.
It has been dealt with and considered, Mr. Chief.
My lord, by this honorable court, my lord, then I will check up because, I am strengthened. My lord, 2023 judgment I have.
Not 2020.
Because where a specific distinction, my lord, may I, my lord, for just my lords.
Judgment.
My lords.
Justice Indira Banerjee. There the claim was they all came for regularization.
My lord.
All came for regularization.
My lord, latest judge.
That we will not regularize you. So they could say that when you are not regularizing them from the date of their utilization of service, then you give 50%, treat them as temporary status, 50% which will count towards pension. I shall also check up.
My lord Justice Indira Banerjee's judgment, I am not, but 2023 lordship, where the Honorable Supreme Court has clearly carved out a distinction, saying lordship.
Then do one.
My lord.
A copy of the judgment.
My lord, I should.
Give us the citation.
My lord,
check up, and in the meantime,
my lord, 20, I mean, my lord, it's 2023, volume 18, SCC 705. My lord, I am relying on paragraph 2, 3, 4, 5, 7, 9, 13, 14, 16. Now, my lord, what has fallen from my lords?
2023 18 SCC?
Yes, 18 SCC 705. It is Director General Doordarshan Prasar Bharati Corporation of India, and another versus Majai S. Desai.
paragraphs 3, 4, 5,
3, 4, 7, 9, 13, 14, 16. Here, the Honorable Supreme Court has carved out a difference, saying, here, my case is, is going to for lunch, therefore I am taking 5 minutes of my lunch. Because I will not complete the argument, but why I am giving something for my lord's thought, that my line of argument. In railways, we have distinct, and as far as our manual is concerned, casual laborers are described under our manual in a different manner, and temporary are described in a different manner. Now, my lord, I will also rely on Uma Devi's case, state of Karnataka. Starting from what now, my lord, initially in 84 as token checkers, because they were acting in adherence to the main ticket collectors in 1984. They were employed as temporary employees, and then they were discontinued in 85. They went to the Honorable Tribunal in 86 saying that no, we need to be absorbed. Honorable Tribunal in 1986 said they are temporary employees, not casual employees. It was denoted to them that they were temporary employees, so they need to be regularly absorbed. That time they were litigating employees, as in Uma Devi. 86, Lordship, that we kept them as temporary at that point of time, and we came to this Honorable Court in appeal with that 86 judgment, that you cannot ask these temporary employees to be regularized. Now, Honorable High Court decided against us. We went to the Honorable Supreme Court. Honorable Supreme Court, the passage which was I was being led to read, decided nothing doing. Temporary employees, they need to be regularized. So, Lordship, what happened? 86 judgment of taking them as temporary employees, denoting them not as casual employees, denoting them specifically as temporary employees under our manual. They were given service by us, regularized, their service was regularized by us in 1993. 1993. From 1993, they became permanent workers. 22nd of July. 22nd of July. Now, he took a voluntary retirement. 2014. No challenge, nothing. After taking VRS, then he is claiming that from 84 till 1991, 84, he was taken as temporary employee, continued in 85. He challenged that discontinuation in 86. 86, so, my lord, 84 to 93, he was a litigating, and 93, we adhered to the order of the Honorable Supreme Court. Now, my lord, my only point is, nothing more, nothing less, only small window of salvation. Under our rules, if he is a temporary employee, this judgment which I have cited before my lords, the Honorable Supreme Court has said that if he is a temporary employee, he is not entitled to that 50%. If he is a casual, he is entitled. Because the Honorable Supreme Court has carved out a thin line of difference between temporary employee and casual employee. This is the case which I am very humbly trying to make out before my lord. It is a very thin line, Lordship. And for that, my lord, I will rely on Uma Devi also, where Uma Devi, paragraph 4 and 49 says that if there is a scheme, because my lords will have to balance the convenience. Union of India or employers are also under Uma Devi, my lords knows. So Uma Devi carved the balance. So, Lordship, I will rely on that. And why I am challenging the order of the Honorable, my lord? Yes, my lord. Yes, he took voluntary retirement in 2014. Then he got emancipated.
Years, years.
2014, Lordship. And received all retirement benefit without any qualms and demur.
Subsequently clearing.
We have stated that, Millets. So, Millets.
Now he is getting pension.
Lordship, everything. My lord, he is claiming from 1984, when he was given that temporary employment, till he was made permanent in 1993, there was a period of around 9 years. Yes, my lord, saying that I am a casual employee. So, in light of that judgment, which my lord was my lord showing me the path, in line of, but my lord, that is not applicable to him. There is no straitjacket formula. So, my lord, this is the long and short of my case. My lord, I will hand over judgments to my lord's officer today. Copy, my lord. My lord, what is happening, my lord, I will candidly submit before my lord. What is happening is because I am doing motley matters. One under the POSH Act, another under this Act. So, my lord, the judgments were there. 2 copies there, one has gone into some other brief. So, my lord, I am with only 2 judges. So, my lord, I will supply it to my lord's officers. So, my lord, that is the long and short of my case. If my lord kindly, since my lord is taking it, my lord will kindly take up my pleadings. My lord will kindly come to petition paragraph. He was never a casual. He was inducted as a temporary employee, and that has been held by the tribunal, which he did not challenge and upheld till the Honorable Supreme Court in 1991. And as a temporary employee, he was absorbed as permanent. And then with that particular understanding, he took VRS in 2014, took all the benefits without any demur.
So 1984 to 1993.
Lordship, he is claiming 50% as a casual employee. And the Honorable Tribunal, temporary employee, because my lord will kindly appreciate, we have stated, if my lord kindly takes up page 4, paragraph 4, we have categorically stated, which is verbatim to his application. My lord will kindly come to paragraph 4A. May I read?
Now, why he is claiming that because 1984 to 1993 it was regularized as
No. Lordship, 1993. My lord, may I?
He was regularized when?
1993. Because, my lord, he was a litigating employee, as Uma Devi has said in paragraph 4. What? My lord got it? Initially, he was taking as temporary employee because in those days, my lords will remember.
Prior to 1984, what was the nature of his work?
No work. He was employed in 84. My lord will kindly see the paragraphs. He was employed in 84. We took him as ticket checking volunteer who was adhering to the job of the ticket collector or ticket checker. Because people used
the order of 18th September 2018.
18th September 2018.
By which you rejected this case.
My lord. My lord will kindly bear me. September. How I have prepared the brief, Millard. I am just taking.
Of September is the order you passed.
Lordship, I passed. I passed, my lord. That was challenged. And my lord will kindly come to the impugned order. My lord will kindly see in the impugned order, it has been categorically stated. Yes. My lord, that is that page.
18th September.
18th September, na?
আমাদের order.
আমাদের অর্ডারটা হলো 120 my lord 120 page number 120 তো
Page 120.
Thank you. List of date, it will be more adequate, my lord, for me to address your lordship in a proper manner so that I'll not waste my
You
lordship.
are claiming temporary status for which period?
No, my lord, temporary status. No. Initially, I was appearing in the 84
Achha, you
as a
must keep a list of dates. We have extensively heard. We have
Very good.
My
Yes.
Lordship, I appear for the respondent.
Lordship, I am for the petitioner's lordship. I am praying for not today, Lordship.
What is the matter?
Lordship, this
Your advocate.
Lordship, my senior is Advocate Pradut Shaha.
Your senior.
Advocate Pradut Shaha.
Mr. Bajpai, I believe he's leading.
What is the
Yes,
matter?
yes.
About?
Matter is regarding, my lord, stepping up of pay, my lord.
Stepping up of pay.
My lord, I am the senior most in the
Promotional post, you are senior.
yes, my lord. And my junior, my lord, he has already received the benefits. And I'm also covered by the judgments of the coordinate bench of this two judgments, my lord.
Covered, today we pay, delivered an order. Today we pass the order.
Lordship, may I?
Stepping up, you cannot deny, provided in the promotional post he is senior.
He is senior. And today only.
Where is Mr. Basu?
Lordship, he is unable to attend because of he is engaged in another matter. Engaged in another matter, Lordship.
He is the advocate on record, my lord.
Yes, yes, Lordship.
Lordship, can I hand over the judgments, my lord? The previous judgments.
Just item number 17, we have.
I was there, my lord.
Oh.
Yes, next.
My lord, I am for the petition. I am praying for not today.
Yes.
I am for the respondent, my lord. You have to submit some documents or marriage certificate or something like that.
Item number 20.
20, yes, my lord.
Marriage certificate. This is by.
Because they have claimed family pension.
They have claimed family pension.
Family pension.
Tribunal rejected.
Tribunal rejected.
Why?
Because there is ambiguity in her claim. She is not the married wife of the applicant, of the deceased applicant.
Oh.
So, matter stands there.
Pension already paid.
No, my lord. Not yet started.
No. The husband expired.
Husband expired.
Family pension.
Family pension, yes, my lord.
When did he expire? When did the husband expire? It is due from which date? I come tomorrow, let us. Not today, go. All right, come tomorrow. No adjournment on the next day. We are going to dispose it of.
Monday, madam.
Monday.
Let's not.
Combined list ডেকে দাও বাইশ থেকে 29
Only thing is, my lord, so far as item number 17 and 18, my lord.
Item number 34, 35, item number 56, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47,
ওইটা হিয়ারিং এর একটা গ্রুপ ডেকে ওটা দাগ করে গেল। ডেকে দাও।
My lord, and that has not been called, my lord. On the last occasion, I am led by Mr. Parthasarathi Bhattacharya, 17 and 18 of the monthly list, my lord.
It was called on Partho Bhattacharya appeared.
Yes, my lord. I am led by Mr. Partha Bhattacharya, my lord.
He was here. You ask him.
It will be called on Kotu.
Yeah, I was also there along with him on the last occasion on Thursday.
No, yeah,